This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast.
Okay, let's unpack this. Imagine you're part of an investment group, maybe, say, from the U.S., and you've been a shareholder in a Luxembourg company for years. The company, well, it has other investors too, maybe some from places like the Caribbean. Now, for whatever reason, strategic, commercial, your group needs to get out, exit the investment.
Right, a common scenario.
You need to sell your shares, sure, but you also need to completely step away from all the commitments, the responsibilities you signed up for in that original shareholder agreement, you know, the one with the other investors and the company itself.
Yeah, it sounds simple on the surface. Exactly. Just sell the shares, right?
Yeah.
But actually stepping out of a complex multi-party contract, like a shareholder agreement, especially when it spans different countries, different legal systems, well, it gets complicated fast.
Oh, it really does.
So how do you make that happen cleanly, legally, and without leaving any loose ends or lingering liabilities?
It certainly does get complicated. This isn't just a simple share transfer. It's really a carefully orchestrated legal and corporate maneuver, and it involves multiple jurisdictions.
Right.
We've taken a deep dive into quite a stack of source material here, articles, research detailing a real-world case study. This one involves investors in the Americas and the Caribbean who invested in a Luxembourg company, a Luxco.
Okay.
And this case specifically looks at how one of those original investors, like the U.S. one in your scenario, makes that clean exit from the shareholder agreement.
Got it. So we're tackling a specific and, often intricate maneuver, the corporate novation of a shareholder agreement, but in a multi-jurisdictional context.
Exactly.
It sounds technical, I know. But it's actually a practical problem, something that comes up pretty frequently in these cross-border involvement structures.
All the time.
So our mission today in this deep dive is to break this intricate process down, step by step. We want to cut through the jargon, uncover the essential legal bits, the corporate stuff, the practical elements, basically everything you absolutely need to understand to make sense of it all.
We're definitely aiming for those aha moments, where the complex pieces suddenly click into place.
Yeah, exactly.
And for you listening, especially if your work touches on, say, legal, financial services, corporate governance, or compliance, particularly within these international structures, well, understanding the mechanics of this process isn't just academic. It's fundamental.
How so?
It's fundamental to executing strategy effectively, to managing risk properly, and frankly, to making sure your deals actually work on the ground across different jurisdictions. If you overlook a key detail in one country's law, or maybe another's corporate procedure, it can derail the whole thing.
Absolutely. So think of this deep dive as like lifting the hood on one specific but very common type of complex cross-border transaction.
Good analogy.
We're going on a journey looking at the who, why, when, what, where, and how of this specific type of corporate novation. We'll use our case study as the guide.
Okay.
We'll start by getting to grips with the core legal instrument. That's the concept of novation itself. And we need to understand exactly why it's the necessary choice here, rather than something that might seem simpler, like, I don't know, a basic assignment.
That choice really is the critical starting point. And you're right, choosing novation over assignment isn't just some technical preference, it's actually a strategic necessity. It's fundamentally driven by the commercial goal of the exiting party wanting that complete clean break.
Okay, so let's define it then. What is novation at its core, and how does it actually achieve that clean break?
Okay, so at its heart, novation is a legal mechanism. Its purpose is to completely replace one contract with another, and in doing so, it fundamentally changes the parties involved. The sources define it as a tripartite agreement.
Tripartite, meaning three parties.
Exactly. Three parties actively involved, all agreeing to the change. Its defining feature is this dual effect. It simultaneously extinguishes, or you could say, cancels the existing contract between the original parties.
Okay, wipes the slate clean for the old one.
And at the same time, creates a brand new contract on the very same terms, but now between the remaining parties and the new party who's stepping in. And the crucial part here, the really critical bit, is that it transfers both the rights and the obligations.
Both sides.
Both sides. The benefit and the burden moving from the outgoing party to the incoming party.
Okay, so it extinguishes the old, creates a new one, transfers both rights and obligations. You don't just get to pick the good bits. Now, what's the absolute non-negotiable requirement for this whole thing to even get off the ground?
The single most critical requirement, the one that can honestly make or break the entire deal before you even get into the serious drafting. It's consent.
Consent?
Yes, the explicit active consent of all three categories of parties involved. You need the outgoing party, our U.S. investor, to agree. You need the incoming party, the Caribbean investor, to agree. And critically, you need every single one of the continuing parties to agree.
Every single one. Who are the continuing parties in our Luxco example?
Well, that would be all the other existing shareholders who are staying in the shareholder agreement. Plus, and this is important, the Luxco company itself, if it was originally a party to that agreement and has obligations under it, which it usually does.
Wow, consent from everyone involved. In a diverse shareholder group, that sounds like a significant practical hurdle. Could one dissenting voice actually stop the whole thing?
That's absolutely correct. It can. And it really reflects the legal basis for novation. Under Luxembourg law, which is governing our Luxco here, the whole concept of substituting one party for another in an obligation, well, it's specifically governed by the Civil Con, Articles 1271 and following.
Okay, the Luxembourg Civil Code.
Yes. And these articles describe the effect of novation as a complete replacement of one debtor by another. It establishes a totally new, direct contractual relationship between the incoming party and all the continuing parties. So that consent requirement, it's inherent in the process because you're fundamentally altering the contractual relationship for everyone who's staying. They're now dealing with a different entity.
Okay, that makes sense legally. So that's novation, full substitution, needs universal consent. Now, let's contrast that with assignment. You mentioned it's more limited. How exactly does assignment fall short for our U.S. investor who wants that clean exit?
Right. Assignment is definitely a different beast. It's generally a much more limited tool. When you assign a contract, typically you're transferring only the rights or the benefits you hold under that contract to someone else.
Like assigning the right to get paid.
Exactly, like assigning the right to receive a payment. But, and this is the crucial distinction, the originor party, the assignor, generally remains legally responsible for fulfilling the obligations under that contract. The duties don't automatically transfer with the rights.
Hold on. So if I assign my right to get dividends from the Luxco under the shareholder agreement, I could potentially still be on the hook for my obligation to, say, chip in for future funding rounds if the company needed capital later.
Precisely. You've passed on the potential upside, the dividend rights, but the legal burden, the responsibility to perform the duties and obligations, that stays with you, the original party. The other parties to the contract, they haven't agreed to release you from those duties just because you've transferred your rights elsewhere.
And this is exactly why novation is essential for a complete shareholder exit, right? Like our U.S. investor wanting out of the Luxco deal. Not just assigning their shares. You can't just hand over the shares and assume your obligations vanish.
Exactly right. Let's apply this directly to our case study. The U.S. investor, the outgoing party, wants a full, complete exit from all aspects of their involvement, not just giving away potential future dividends. If they simply assign their rights under the shareholder agreement, maybe rights to information, preemption rights, rights to distributions, that would be commercially and legally totally insufficient.
Why? What are the obligations they'd still be stuck with?
Well, shareholder agreements, especially in private companies like this Luxco, they contain significant obligations. Our sources detail these quite clearly. Things like commitments to provide future funding if needed, strict confidentiality undertakings, potentially non-compete or non-solicitation clauses, obligations to participate in governance, attend board meetings, shareholder meetings, stick to agreed decision-making processes, and so on.
Right. It's a really reciprocal relationship.
Yeah.
Lots of ongoing responsibility.
Precisely. So an assignment. It would transfer the passive benefits, sure, but it would leave our U.S. investor legally bound by all those original ongoing obligations. They'd no longer have any economic interest in the company, having sold their shares, but they'd still be legally exposed to liability for performance, potential breaches of the shareholder agreement.
Yikes.
Our source material accurately describes this potential outcome for the outgoing party as an untenable situation.
Untenable is putting it mildly. No financial upside, just this cloud of perpetual legal risk.
Yeah, exactly. So novation, and crucially only novation, allows for that full substitution. The incoming party steps completely into the shoes of the outgoing party by extinguishing the original agreement specifically as it relates to the outgoing party and simultaneously creating that new identical agreement where the incoming party assumes all roles.
Yeah.
Well, that is how the outgoing party achieves the crucial commercial objective, a complete release.
A release.
A complete release from all future rights and obligations under the agreement, effective from the date of the novation. This release is the fundamental commercial driver. It's why they choose novation.
So that full legal release is absolutely key. And that loops us back to the consent requirement again, doesn't it? If you need all parties to agree to the novation, does that really mean any single existing shareholder who says no? Even a tiny one could effectively block the whole transaction.
That's correct. In a multi-shareholder environment like our Luxco case study, this consent requirement essentially gives every single continuing party, every other shareholder, and potentially the company itself a veto power. A veto over the outgoing party's ability to exit cleanly via novation.
Wow.
And this is why, practically speaking, preliminary consent gathering is such a crucial first step. Before you spend significant time and money drafting complex legal documents, organizing corporate procedures in Luxembourg, you need to informally, or sometimes formally, sound out and secure that necessary buy-in from all the continuing parties. If you don't have it, honestly, you shouldn't proceed.
That's a really vital, practical takeaway. Don't run up the clock in the legal bills until you know everyone's likely on board. Okay, let's really hammer home the differences between novation and assignment. Our sources often use a table for this, which is helpful.
Yes, it's a very clear way to see why the choice matters so much. Let's walk through the key points of comparison.
Okay, first point.
First, legal effect. Novation extinguishes the old contract and creates a new one with substituted parties. Assignment merely transfers specific rights or benefits under the existing contract.
Okay, extinguishes versus transfers rights. Got it.
Second, transfer of obligations. Novation transfers both rights and obligations, the benefit and the burden, from outgoing to incoming. Assignment transfers only the rights or benefits. The obligations stay with the original party, the assignor.
Huge difference. Third point.
Third, consent required. For novation, consent from all three categories, outgoing, incoming, and all continuing parties, is mandatory. It's a matter of law. For assignment, consent from the other original party might be needed, but it often just depends on what the original contract says. It's not usually a universal legal requirement just to transfer rights.
Okay, mandatory total consent versus maybe needing consent based on the contract. Fourth,
original contract status. With novation, the original contractual relationship between the outgoing party and the continuing parties is terminated and replaced by a new relationship between the incoming party and the continuing parties. With assignment, the original contract between the assigner and the counterparty generally stays in force. It's just that the assignee now holds the assigned rights.
Right, replaced versus remains in force with a change. And finally,
liability of outgoing party. Under novation, the outgoing party gets that complete release from all future liability under the contract from the effective date. Under assignment, the original party, the assigner, remains liable for performing the contractual obligations.
looking at those points side by side, especially the transfer of obligations and that release from future liability, yeah, it's absolutely undeniable why novation is the essential tool for a shareholder wanting a clean, complete exit. Assignment just wouldn't cut it at all.
Absolutely not. It leaves that unacceptable lingering exposure.
So thinking about these distinctions, maybe for you listening, which difference really stands out as the most critical in your experience? And perhaps thinking the other way, can you think of common scenarios you've run into where assignment was the perfectly appropriate mechanism? Maybe because only rights, not really any significant obligations, needed transferring.
Oh, sure. A classic example where assignment works fine is just transferring the right to receive payment under an invoice. Or maybe assigning the benefit of a simple loan. The identity of the lender changes, but the debtor's core obligation to repay stays exactly the same. You're not shifting a complex web of duties there.
Makes sense. Okay, great. We've firmly established why novation is used and how it crucially differs from assignment for this kind of shareholder exit. Now, let's dive into the nitty-gritty. Let's look at the central document that makes this all happen, the novation agreement itself.
Right. The novation agreement. You could think of it as the legal blueprint for the substitution. Now, its form can sometimes be relatively simple, maybe just a letter agreement attached to the main share purchase agreement. But its content, the wording, has to be incredibly precise to achieve the desired legal effect. It needs to clearly spell out the terms of the substitution and, crucially, record the consent of all the parties involved.
And our source material gives a helpful breakdown of the essential clauses you'd expect to find in such an agreement. Let's walk through them, starting with, maybe obviously, the parties clause.
Yes, sounds obvious, but it's fundamentally important to get this right. The agreement must clearly, unambiguously identify who is who. You need to list the outgoing party, our U.S. investor, the incoming party, the Caribbean investor, and then meticulously list all of the continuing parties.
And as you said, the continuing parties isn't just the other shareholders staying in.
Correct. It often, and crucially, includes the Luxco itself, the company whose shares are the subject of the whole agreement.
Why does the company itself need to be a continuing party and sign the Novation agreement?
Well, because the original shareholder agreement almost always imposes obligations directly on the company. These could be things like obligations to provide financial reports to shareholders, maybe obligations to facilitate share transfers according to preemption rights laid out in the agreement, or duties related to calling shareholder meetings. Since the company has these ongoing duties under the agreement, its consent to the novation is required. And it needs to be a party to the new novated arrangement to make sure those obligations continue to be enforceable by the incoming party.
Makes perfect sense. The company has to acknowledge the new player and its own continued responsibilities towards them. Okay, next up, the recitals.
The recitals. This is the introductory section, often starting with those whereas clauses you see in legal documents. Their job is really to set the factual background, provide the context for the agreement.
What kind of context?
It will typically reference the original shareholder agreement, the date, the parties. It will state the outgoing party's intention to transfer their shares and exit the agreement completely. It'll state the incoming party's desire to step in. And, very importantly, it formally records that all the necessary parties have consented to this substitution. It basically lays the foundation and explains the rationale for the legally binding operative clauses that come next.
Okay, so it sets the scene and confirms that initial, absolutely crucial consent has been obtained. Then we get to the real heart of the agreement, right? Operative Clause 1, Novation and Release.
This is it. This is where the legal magic happens, or rather, where it's explicitly spelled out. This clause contains the precise legal language needed to actually effect the novation. It will clearly state that, as of the agreed effective date, the original shareholder agreement is extinguished, but specifically only as it applies to the outgoing party. And simultaneously, a new agreement, on identical terms, is created between the incoming party and all the continuing parties.
On the release part.
And critically, this clause includes the language that grants the outgoing party that full and final release. A release from all duties, all obligations, all liabilities arising under the original agreement, but crucially from the effective date onwards. This clause is the legal realization of that core commercial objective, the clean break.
That's the money shot for the outgoing party.
Yeah.
Getting released from future liabilities. Okay, what about the incoming party? How does the agreement make sure they formally commit to stepping into those shoes?
That's handled in Operative Clause 2, Assumption of Rights and Obligations. It's essentially the mirror image of the release clause. Here, the incoming party formally covenants, meaning they make a binding legal promise to assume all of the rights and to perform all of the obligations that the outgoing party had under the shareholder agreement. They agree to be bound by all the terms, just as if they had been an original signatory from day one. They completely step into the role the outgoing party is vacating.
Got it. So outgoing is released from the future. Incoming assumes all of it going forward.
Yeah.
But what about the past? What about liabilities for things that might have gone wrong before the novation date? Mistakes the outgoing party might have made while they were a shareholder.
Excellent question. And that's precisely the purpose of Operative Clause 3, treatment of pre-novation liabilities. This is a point that is almost always subject to significant negotiation between the parties. The basic legal principle is that novation, by itself, only really deals with the future. It doesn't automatically extinguish liabilities that the outgoing party might have incurred for breaches or non-performance that happened before the novation took effect.
So you can't just use novation as a sort of get-out-of-jail-free card for past mistakes.
Absolutely not. The agreement must explicitly address how these prior liabilities are handled. What typically happens is the outgoing party remains liable for their own past breaches. The incoming party, who is stepping into an existing ongoing contractual relationship, needs protection against potential unknown issues lurking from the past.
How do they get that protection?
This is where the outgoing party will commonly be required to provide specific representations and warranties. These are essentially legal assurances about the state of affairs before the novation, like warranting that they haven't breached the agreement, for example. And they'll often provide indemnities, which are promises to compensate the incoming party for any losses they might suffer down the road due to past actions or omissions by the outgoing party.
That makes a lot of sense. Incoming takes on the future, but needs some safeguards against inheriting past problems. Okay, now, you flag the next clause as being particularly interesting and very specific to the governing law. Operative Clause 4. Preservation of security, sometimes called the Article 1278 clause. Tell us why this one is so critical, especially under Luxembourg law.
Yes. This clause is a perfect example of why you really need lawyers who know the specific governing law inside out. Here's where it gets into those critical details that professionals absolutely need to watch out for. This clause is vital, particularly when the deal involves any kind of financing or security interests linked to the shares or the Luxco. Things like share pledges, guarantees, which are extremely common in these investment structures.
Okay, so relevant when there's security involved. What's the issue it addresses under Luxembourg law? You mentioned Articles 1278 and 1281 of the Civil Code.
Exactly. Article 1281 in particular contains a rule that, well, it could potentially be interpreted to mean that when a novation extinguishes the original obligation, like the old shareholder relationship with the outgoing party, it could also potentially extinguish any ancillary security interests attached to that obligation.
Ancillary security interests, like the share pledge.
Yes. Things like share pledges given by the shareholder, or maybe guarantees they provided related to their obligations. The risk under Article 1281 is that these could be wiped out by the novation unless the creditors, the parties who benefit from these securities, have expressly reserved their rights to maintain that security for the new obligation being created with the incoming party.
Wow. So the very act of novation, which is supposed to smoothly substitute one party for another, could inadvertently kill the collateral that underpins the whole deal. That sounds like a potential disaster waiting to happen for the remaining parties.
It absolutely could be if you don't handle it correctly. This preservation of security clause is precisely the necessary express statement required by Article 1281. It's an explicit declaration within the novation agreement made by the relevant parties, especially those holding the security, stating clearly that any existing share pledges, guarantees, or other security interests connected to the original shareholder agreement are preserved. They continue in full force and effect, now securing the obligations of the incoming party under the new novated agreement. It effectively prevents the accidental and potentially very costly release of crucial collateral.
That's fascinating. A really deep dive into a specific point of the Civil Code with huge practical consequences. So this clause is basically a direct legal countermeasure against a specific risk posed by the governing law itself.
Exactly. It's a prime illustration of why using generic template agreements isn't enough in cross-border deals. You absolutely need specific legal expertise applying the nuances of the governing law to the transaction's concrete details.
Okay, very clear. Moving on. Operative Clause 5. Conditions precedent, CPs. We've mentioned these a couple of times, and you said we'd cover them in more depth later. What's their function within the novation agreement itself?
Right, CPs. They're standard furniture in almost any complex transaction agreement. Essentially, they act as a gatekeeper. They state that the party's obligation to actually proceed to closing, the final step where the novation becomes legally effective, funds are transferred, etc., is entirely suspended until certain specified conditions are met, or may be formally waived by the party they benefit. They are fundamentally a risk management tool.
How do they manage risk in this context?
Well, they protect the parties from being legally locked into completing the deal until certain external dependencies are sorted out. These are usually things outside their direct control, but things that are essential for the deal to be either viable or legal.
Can you give us some examples? What are common CPs you'd see in a deal like this?
Sure. Typical CPs might include obtaining mandatory regulatory approvals, maybe antitrust clearance if the deal hits certain thresholds, or, crucially in our case study context, getting any necessary regulatory nods or making required filings in the offshore jurisdiction of the incoming party, like the Cayman Islands, which we'll definitely dig into more.
Okay, regulatory approvals. What else?
Other common ones are securing necessary consents from key third parties. For instance, banks providing financing to the Luxco might have clauses in their loan agreements triggered by a significant change of shareholding. So getting the bank's consent could be a CP. Another big one is obtaining the necessary corporate approvals within the Luxco itself, specifically the shareholder resolutions passed at that EGM we need to talk about.
Right, the EGM approval as a CP. Makes sense. Now, what's the legal consequence in Luxembourg if one of these CPs just isn't met by the deadline set in the agreement? Does the deal just fall apart?
Under Luxembourg contract law, which is based on the civil code, the effect is pretty clear. If a condition precedent isn't fulfilled by the agreed-upon deadline, and assuming it hasn't been waived by the party it's meant to protect, then the obligations that were suspended by that CP simply lapse. The agreement effectively fails at that point, and neither party is required to proceed to closing.
Okay, so failure to meet a CP generally kills the deal. Is there any protection against someone deliberately messing things up?
Yes. Luxembourg law, like many legal systems, includes protection against bad faith actions. Article 1178 of the Civil Code specifically states that if a party whose obligation is conditional upon a CP actively prevents the fulfillment of that condition, the law may actually treat the condition as having been fulfilled anyway. It's a sort of sanction against misconduct, preventing someone from deliberately sabotaging a CP just to wriggle out of a deal they've had second thoughts about.
That's a smart protection against potential foul play.
Yeah.
Okay, finally in the agreement clauses, the governing law and jurisdiction clause. Seems standard, but absolutely essential here, right?
Absolutely essential, yes. This clause dictates two critical things. First, which country's laws will be used to interpret the terms of the agreement if there's a dispute about meaning, and second, which country's courts will have the authority, the jurisdiction to resolve any disputes that might arise. In a cross-border transaction involving a Luxembourg company and a shareholder agreement that's likely already referencing Luxembourg corporate law, it's standard practice and really the logical choice for the Novation agreement itself to also be governed by Luxembourg law.
Why is that logical choice so important?
It ensures consistency. It avoids potentially complex and costly conflicts of law arguments down the road if different agreements related to the same core transaction were governed by different laws. Sticking with Luxembourg law for the Novation provides clarity and predictability.
Okay, we've really dissected the Novation agreement, now the legal heart of the transaction. That covers the first pillar, the contract. But as you said earlier, there are three pillars. The second pillar is about making sure this change is properly anchored within Luxco's own corporate structure. That involves formal corporate action, right?
Exactly right. The Novation agreement is legally binding on the parties who sign it, sure. But remember, a shareholder agreement is primarily a private contract. It's between the shareholders and the company. To make certain key provisions, particularly things related to share transfer restrictions, or maybe rules about the composition of the shareholder base to make those provisions durably enforceable against the company itself, and importantly against third parties who aren't signatories to the private agreement, it's best practice for them to be reflected or at least referenced in the company's official constitution.
And that's the Articles of Association.
Yeah, the Articles of Association, they are the fundamental constitutional document of the company.
And they are public, right? Filed somewhere.
Correct. They are filed with the Luxembourg Trade and Companies Register, that's the RCS we mentioned earlier, and they are published in the official electronic gazette, the RISA. Their terms are legally binding on the company, on all its shareholders, present and future, and because they're public, third parties can rely on the information contained within them.
So when a new shareholder, like our incoming party from the Caribbean, comes in via Novation, why is amending the articles often necessary, or at least best practice?
Well, it's crucial if the articles themselves contain, for example, an embedded list or register of shareholders that needs updating. Or perhaps there are other provisions in the articles that need consequential changes to reflect the new shareholders' presence, or maybe specific rights or obligations that were previously held by the outgoing party and are now transferring. Essentially, you want the company's public constitution to accurately reflect the reality agreed in the private Novation agreement, especially regarding who the shareholders are and any key governance mechanics linked to them.
Okay, aligning the public articles with the private agreement. And under Luxembourg law, specifically that venerable law of 10 August 1915 on commercial companies, which still forms the bedrock amending the articles of a public limited company, an SA, Société Anonyme, requires a very specific and formal procedure, doesn't it?
It absolutely does. Any amendment to the Articles of an SA requires a resolution to be passed at an extraordinary general meeting, an EGM. And critically, for an SA, this EGM must be held in the formal presence of a Luxembourg notary.
A notary? Why the mandatory notary?
The mandatory notarial involvement really elevates the corporate decision. It turns it into an official public act recorded by an independent legal professional. This process is how you take the change that was agreed in the private novation agreement and give it that formal public effect within the Luxco's corporate structure. It makes the change legally robust and enforceable against everyone.
Okay, so amending the articles via a notarial EGM is the core mechanism for this second pillar. Let's walk through the formal path for convening this EGM step by step as laid out by that 1915 law. First off, who is responsible for actually calling this meeting?
The EGM is normally convened by the company's board of directors, or, depending on the specific governance structure of the SA, it might be the management board.
Okay, the board calls it. What about the notification process? How do the shareholders find out about it, and how much advance notice do they need?
The method and the timing of the convening notice actually depend on the type of shares the SA has issued.
How so?
If all the company's shares are in registered form, meaning they're recorded in a shareholder register with specific names and addresses, then the notice must be sent via registered mail to each shareholder at their registered address, and it has to be sent at least 8 days before the date scheduled for the meeting.
Okay, registered mail, 8 days notice for registered shares. What if they have bearer shares?
Bearer shares. Those are the physical share certificates not registered in a specific name. If the company has issued any bearer shares, the law requires a more public form of notice because you need to reach potentially unknown holders. This involves publishing the convening notice in 2 places. First, in the Recueil électronique des sociétés et associations, the RESA, that electronic official gazette we talked about, and second, in a Luxembourg newspaper that has sufficient circulation. And for bearer shares, this public notice must be given at least 15 days before the meeting date.
So bearer shares trigger a more public, longer notice period, 15 days. RESA plus a newspaper. What information absolutely has to be in this convening notice, regardless of how it's delivered?
It's quite detailed. The convening notice must contain the specific and complete agenda for the EGM. It's not enough just to say amendment of articles. For each proposed amendment, the notice must include the full text of the resolution that's going to be voted on, including the exact proposed new wording of the amended articles.
The full text. Wow.
Yes. And furthermore, a report from the board of directors explaining the reasons and justifications for these proposed amendments must be made available to the shareholders. They need to be able to consult it at the company's registered office before the meeting.
Full text of the changes and a board report explaining why. That sounds like a fair bit of preparation just for the notice itself. Okay, so shareholders are notified. What about the meeting itself? What are the attendance and voting thresholds required to actually pass the resolution to amend the articles?
The 1915 law sets relatively high bars here, specifically for amending the articles. This is designed to protect minority shareholder rights by requiring a broad consensus. First, for an EGM to even validly deliberate on amending the articles, you need a quorum.
A quorum?
Yes, a minimum attendance level. At least 50% of the company's total issued share capital must be present or represented by proxy at the meeting.
Okay, 50% of the capital needs to show up or send a proxy just to get started. And if you meet that quorum,
if that 50% quorum is met, then the resolution to actually amend the articles requires a supermajority vote. You need at least 2/3 of the votes cast by the shareholders who are present or represented at that meeting.
Okay, 50% present or represented to start, then 2/3 of the votes cast to pass it. And you said all of this has to happen in front of a notary.
Yes, the physical meeting of the EGM must take place in the presence of a Luxembourg notary. The notary's role here is absolutely central to the process. They verify the identity and legal capacity of the shareholders present or represented. They confirm that the quorum and majority requirements, the ones mandated by the 1915 law, and maybe any stricter ones in the company's own articles, have actually been met.
So they act as an official checker.
Exactly. And then they formally record the entire proceedings, including the exact resolutions that were adopted in an official notarial deed. This deed becomes the formal, authentic legal record of that corporate action.
And what happens with that notarial deed afterwards?
The notarial deed is then filed by the notary with the Luxembourg RCS, the company's register. And subsequently, it's published in the RESA, the official gazette. It's at this point, the formal filing and publication, that the amendments to the Articles of Association become legally effective and enforceable. not just between the company and its shareholders, but also against third parties.
Okay, that's the formal statutory path laid out by the 1915 law. It involves specific notice periods, minimum thresholds, mandatory notarial involvement. Honestly, it sounds like a process that could easily take several weeks, maybe even a month or more, to execute properly from start to finish.
It certainly can, yes.
But you mentioned earlier there's an express lane available, especially for private companies.
Yes, absolutely. And this is where Luxembourg law provides a very practical and highly efficient alternative. It's extremely common, almost standard practice actually, in private equity deals, M&A transactions involving private essays, basically anywhere you have full shareholder alignment. The 1915 law allows an EGM to be held without any prior convening notice, skipping those statutory notice periods entirely, provided two specific conditions are met right there at the meeting itself.
Okay, what are the two magic conditions for this express lane?
First, all of the company's shareholders must be present or validly represented by proxy at the meeting. 100% presence or representation.
100%. Wow. Okay, what's the second?
Second, all shareholders present or represented must unanimously agree to waive the formal requirements for convening the meeting. They have to explicitly state that they have been duly informed of the meeting's agenda and the text of the proposed resolutions, and they all agree to proceed without the formal notice.
So let me get this straight. If literally everyone shows up or sends a proxy and everyone agrees on the spot to skip the formal notice period and procedures, you can just get straight down to business.
Exactly. It completely bypasses that potentially multi-week notice period requirement. In practice, what usually happens is the shareholders, or more commonly their lawyers or authorized representatives holding specific proxies, they all gather at the notary's office.
Okay.
They sign an attendance list proving everyone is present or represented. The notary then presents a waiver document. This is often annexed to the final notarial deed, which all shareholders or their proxies sign. This document confirms their presence, confirms they know the agenda, and confirms their unanimous agreement to waive the convening formalities. Once that waiver is signed and verified by the notary, boom, you can immediately proceed with holding the EGM, discussing the resolutions, and voting right there and then in the same meeting.
That sounds dramatically faster and simpler than the formal route. Yeah. Why is this the default for most private deals then? Is it just speed?
It saves significant time, yes, but also administrative effort and therefore cost. Instead of a process stretching across several weeks, maybe involving registered mail, tracking receipts, or placing newspaper publications, you can literally complete the entire corporate action, convening the EGM, and passing the necessary resolution in a single meeting at the notary's office. Often, this is done as part of the overall transaction closing sequence. It achieves the exact same legal outcome as the formal route, but with maximum efficiency, provided, of course, you have that 100% shareholder presence and unanimous consent to waive formalities.
Right, that's the catch.
It's a great illustration, though, of how Luxembourg law often provides both strict statutory requirements for protection, but also smart, flexible options for private transactions where consensus exists among the parties.
Yeah, that comparison really highlights the trade-off. The formal path needs the board to convene specific notice methods, those 8 or 15-day minimum notice periods. The waiver path needs none of that before the meeting, but instead demands 100% of the share capital present or represented at the meeting itself, which is much higher than the 50% quorum needed for the formal path just to start deliberations.
Correct. And the voting threshold to actually amend the articles that 2/3 supermajority of votes cast remains the same in both scenarios once the meeting is validly constituted.
So that 100% presence requirement for the waiver path is the real gatekeeper. It tells you this shortcut is only really possible when you have complete agreement and participation from the entire shareholder base.
Precisely. It relies on total alignment.
Okay. So we've covered the Novation agreement, the legal contract. That was pillar 1. We've covered the Luxembourg corporate action, anchoring the change in the company's public constitution via the EGM. That's pillar 2. What was the third pillar you mentioned? Something involving the offshore element.
Yes. The third pillar involves navigating the legal and regulatory requirements of the offshore jurisdiction, where another key party to the transaction is based. In our case study, remember, the incoming party is using an investment vehicle incorporated in the Cayman Islands. Ensuring compliance with Cayman Islands requirements is typically managed through those conditions precedent, the CPs, in the Novation agreement itself.
The CPs again, but this time focused specifically on the offshore piece. Let's talk about their role regarding this Cayman Islands angle. What exactly are the risks they are managing here?
Well, as we discussed before, CPs are those clauses that suspend the obligation to actually close the transaction until certain specified events occur. In the context of the Cayman Islands entity involved here, the CPs are primarily there to ensure that the transaction complies with any relevant Cayman Islands laws or regulations before the incoming party is legally bound to complete the deal and transfer the funds. They essentially ensure that the incoming party's part of the transaction is legally sound from their home jurisdiction's perspective.
Okay, making sure the Cayman entity's side is all squared away before the deal closes. Now, you highlighted earlier that there's a potential pitfall here, particularly around what people often assume is required from the Cayman Islands Monetary Authority, CIMA. You use the phrase, here's where it gets really interesting. Let's unpack that nuance. What's the common mistake?
Yes, this is a very common point of confusion and honestly a potential pitfall in multi-jurisdictional deals involving Cayman entities. Often you'll see deal lawyers or parties who maybe aren't specialists in Cayman Islands regulatory law simply include a condition precedent in the agreement that says something generic like receipt of CIMA approval for the transaction involving the Cayman entity.
Seems straightforward enough.
It seems straightforward, but this condition can be fundamentally incorrect. It depends entirely on the specific regulatory status of that particular Cayman entity involved. You can't just assume all Cayman companies need some approval for everything.
So the type of Cayman company matters immensely.
It matters absolutely everything in this specific context. Let's break down the two main scenarios you'll encounter. Scenario 1. The incoming party's vehicle is a standard Cayman Islands exempted company. This is by far the most frequent type of entity used for international investment holding structures. And importantly, it is not regulated by CIMA for its ordinary day-to-day holding activities.
Okay, so a standard holding company, not directly under CIMA's regulatory thumb for just holding assets. What are the requirements here when it gets a new owner or buys shares in our Luxco?
For this type of common, unregulated entity, there's generally no requirement under Cayman Islands law to notify or obtain any form of approval from CIMA simply because there's a change in its own shareholding, like the incoming party itself being acquired, or because it is acquiring shares in a foreign company like our Luxco. CIMA's approval is just not needed for these basic holding company activities and ownership changes in an unregulated entity.
Okay, so if it's a standard holding company, forget needing CIMA approval for just changing owners or buying foreign shares. What is the relevant Cayman regulatory obligation then, if any? Is there anything they need to do?
Yes, there is a relevant obligation, but it's different. In this common scenario, the key obligation stems from the Cayman Islands framework for tracking beneficial ownership. This is primarily governed by the Beneficial Ownership Transparency Act, or BOTA. The latest version came fully into effect on January 1st, 2025, replacing earlier regimes.
BOTA, okay. Beneficial Ownership Transparency Act, what does it require?
Under BOTA, the Cayman Islands entity has an ongoing duty to identify who its ultimate beneficial owners are. Now, when there's a change in its beneficial ownership, which would happen in our case when the U.S. investor exits and the Caribbean investor effectively becomes the beneficial owner of that slice of the Luxco shares held through the Cayman vehicle, the Cayman entity is required to do two things. First, it must update its own internal beneficial ownership register. And second, it must notify its local registered agent or corporate service provider, its CSP, in the Cayman Islands of that change.
And what does the CSP do with that notification?
The CSP then has the responsibility to update a centralized beneficial ownership platform. This platform is maintained by the Cayman Islands government, but it's important to note it's generally not public.
Okay, so the actual requirement is update internal records, notify your local agent, and the agent updates a non-public government platform.
Yeah, precisely. This is fundamentally a filing and notification duty. It's about transparency, ensuring the authorities know who ultimately owns the company. It is emphatically not an approval process where a regulator, like CIMA or anyone else, needs to review and consent to the change before it can legally happen.
Right, so that CIMA approval CP would be wrong here.
Totally wrong for this type of entity. Therefore, the condition precedent in the Novation agreement for this standard holding company scenario must be drafted with absolute precision. It should refer to something like evidence that the incoming party or its Cayman vehicle has made all necessary filings and notifications under the Cayman Islands Beneficial Ownership Transparency Act related to the transaction, or similar careful phrasing. Just putting in a CP requiring CIMA approval for this kind of entity is legally incorrect. It will likely cause confusion, definitely cause delays, and generate unnecessary questions and costs during the CP satisfaction phase when CIMA says, approval. What approval? We don't regulate this entity for that.
That's a huge practical distinction. A real trap for the unwary drafter. You absolutely need to know exactly what type of Cayman entity you're dealing with.
Okay, so that's the common scenario. What about scenario 2, where the Cayman entity is actually SEMA regulated?
Yes, this is the completely different situation. This is where a SEMA approval CP would be the correct approach. If the incoming party's Cayman vehicle is an entity that falls under direct SEMA regulation. Good examples would be, say, a registered mutual fund, maybe a licensed fund administrator, a licensed trust company, or a securities investment business firm. Then the rules are different.
How so?
In this specific case, a material change in the ownership or control of that regulated entity does require prior notification to SEMA. And SEMA's non-objection, or sometimes formal approval depending on the specifics, is necessary before that change in control can legally take place.
So for a SEMA-regulated entity, the CP should correctly refer to something like receipt of written approval or non-objection from SEMA. Exactly. For a regulated entity, that's the right condition. This whole distinction just hammers home the absolute necessity of conducting specific, granular, entity-level legal and regulatory due diligence right at the very outset of any cross-border transaction involving entities and jurisdictions like the Cayman Islands. You cannot just assume. You must understand the precise regulatory status of the specific counterparty entity to correctly draft the conditions precedent. Get it wrong, and you risk flawed contracts, unrealistic timelines, and unnecessary costs chasing approvals that aren't even required or missing approvals that are.
What really stands out to you most about this BOTA versus SEMA approval distinction? What's the key takeaway?
For me, honestly, what's most striking is how easily a single line in a potentially multi-million-dollar transaction agreement, that condition precedent clause, can be fundamentally wrong, simply because the drafter didn't have precise, specific knowledge of the regulatory framework applying to a counterparty's entity in a foreign jurisdiction. It just underscores that effective cross-border legal work is really about deep local knowledge, not just applying general principles across the board.
That's a powerful reminder of the need for specialized local counsel in these deals. Okay, before we move on to pulling it all together in the practical blueprint, our source material also gives us a quick glimpse into a relatively new tool in the Cayman Islands legal toolkit, the restructuring officer regime. Now, our case study is a solvent transaction, a simple exit. Why is this restructuring tool still relevant context for professionals working in this space?
It's relevant because it reflects the evolving global landscape of how corporate distress and rescue are handled. And that influences how cross-border risks are perceived and managed more broadly, even in solvent deals. The Cayman Islands, like many other major financial centers, including Luxembourg, as we'll see, has recently enhanced its legal framework specifically to make it easier to rescue distressed companies, moving away from a model that was perhaps more purely focused on liquidation in the past.
Interesting. Tell us briefly about this new restructuring officer regime. How does it work?
Okay, so it was introduced through amendments to the Cayman Companies Act back in mid-2022. Essentially, it allows a company that is facing financial difficulties specifically, the test is if it is or is likely to become unable to pay its debts as they fall, due to petition the Cayman court for the appointment of a restructuring officer, or RO.
An RO, what's the key feature?
The absolute key innovation this regime brings is an automatic global moratorium on claims by unsecured creditors. This moratorium takes effect immediately, right upon the filing of the petition for an RO with the court.
An automatic global moratorium. That sounds like a pretty powerful shield for a struggling company.
It is. It gives the company crucial breathing space, protection from creditor lawsuits and enforcement actions. This enables it to negotiate and propose a restructuring plan with its creditors and other stakeholders, all while being overseen by the court and the appointed RO. And, crucially, it allows this without the company having to enter formal liquidation proceedings first.
So it separates rescue from liquidation.
Exactly. This is a significant philosophical shift for Cayman law. It effectively decouples the restructuring process from formal insolvency proceedings. It aligns the Cayman Islands framework much more closely with what you see in debtor-in-possession style regimes like Chapter 11 in the U.S. or the UK's administration procedure. It moves away from more traditional models where initiating a rescue often required putting the company into liquidation first, which can destroy value.
And you see this as part of a wider global trend in how jurisdictions are approaching corporate distress.
Absolutely. It directly mirrors recent legislative changes we've seen in many other jurisdictions, all aimed at developing a more robust rescue culture. As we touched upon in our sources look ahead section, Luxembourg itself significantly updated its own insolvency and restructuring laws with a major new reorganization law that became effective in late 2023. This law also introduced modern judicial and consensual procedures designed for rescue.
So Luxembourg and Cayman are moving in parallel.
In that broad sense, yes. These trends show a global movement towards prioritizing the continuity of businesses and preserving value, even when companies hit financial turbulence, rather than just defaulting to winding them up and liquidating assets. For professionals involved in any kind of cross-border deals, even solvent ones like our Novation case study, just being aware of these evolving tools for managing distress is essential background context. It affects how you think about counterparty risk and structuring deals.
Fascinating to see that parallel evolution towards rescue. Okay, we've now covered the three core pillars: the Novation agreement itself, the necessary Luxembourg corporate action, and the offshore requirements managed through CPs, including those Cayman nuances. Let's try to bring it all together now into a practical blueprint. Let's look at the likely timeline, the costs involved, and those critical tax considerations.
Right, time to translate all the legal requirements and corporate steps into something that looks more like a real-world project plan and budget. Our sources actually provide a synthesized, indicative timeline for a transaction like this.
Okay, assuming things go relatively smoothly, you have cooperation from all parties, and critically, you can use that efficient EGM waiver path in Luxembourg. What's a realistic time frame we're looking at?
Based on the sources, a typical timeline seems to break down into three main phases. Phase 1 is preparation and negotiation. This kicks off after the basic commercial terms are agreed, maybe outlined in a term sheet. It involves doing the detailed legal, financial, and tax due diligence on the Luxco and the existing arrangements. And then, crucially, drafting and negotiating the core Novation agreement and all the necessary ancillary documents, like the share purchase agreement for the actual shares changing hands. This phase. The sources estimate it takes approximately week 1 through week 4.
Okay, so DDD and drafting the main paperwork figure about a month, give or take. Then comes phase 2, execution and corporate action.
Yes. This is really the operational peak. It's where the key legal and corporate documents get formally signed and actioned. It involves securing that formal, written, unanimous consent from all the Luxco shareholders to waive the EGM convening formalities. Then actually holding the formal notarial EGM in Luxembourg to pass the resolutions needed, maybe amending the articles, and then formally executing the Novation agreement itself by all the parties, the outgoing party, the incoming party, and all the continuing parties, including the Luxco. Thanks to that EGM waiver we discussed, this phase can be significantly compressed. It's often targeted for completion around week 5.
Wow, that EGM waiver path sounds absolutely crucial for hitting that kind of condensed timeline for the corporate piece.
Yeah.
Okay, and finally, phase 3, closing and post-closing. What happens here?
This phase is all about wrapping everything up, making the transaction legally effective, and getting things operational. It involves the notary filing the notarial deed from the EGM with the Luxembourg RCS and ensuring its publication in RISA. It involves satisfying all the agreed conditions precedent, for example, getting and providing evidence that the required Cayman BOTA filing has been made by the incoming party's vehicle.
Okay, ticking off the CPs.
Exactly. Then comes the actual closing event. This is typically when the purchase price for the shares is transferred from the incoming party to the outgoing party. And after closing, there are post-closing activities like internally updating the Luxco's own share register and other company records to formally reflect the new shareholder structure. This final phase, the sources estimate, typically takes place around week 6 through week 8.
So let's recap that timeline. In a relatively smooth, cooperative environment, using that Luxembourg EGM waiver, you could potentially go from agreeing the basic terms to having the deal formally closed, registered, and money transferred in about 6 to 8 weeks.
That seems to be the indicative timeline for a well-managed cooperative process, yes. But it's really vital to stress that real-world complexities can easily stretch this out. Unexpected issues popping up during due diligence, maybe protracted negotiations on those contentious clauses we talked about, like who's liable for pre-novation issues, or who pays what costs, or even just delays in satisfying third-party CPs. Any of those can add time, but it gives you a clear sense of the typical sequence and how quickly things can move with the right planning and, importantly, cooperation.
Right, cooperation is key. Now, speaking of costs, executing a multi-jurisdictional transaction like this, involving lawyers in Luxembourg, the U.S., Cayman, plus a notary, it clearly isn't going to be cheap. Who typically ends up footing the bill for all this work?
You're right, the costs can be substantial, and they primarily fall into a few key categories. Legal fees are almost always the largest single component. As you said, you'll typically have multiple law firms involved, each with specific roles.
Like who?
Well, you'll definitely have Luxembourg counsel. They usually act as the central coordinator for the transaction on the ground in Luxembourg. They'll draft the Luxembourg corporate documents, advise on the Novation agreement itself from a Luxembourg law perspective, and crucially, liaise with the Luxembourg notary. Then you'll likely have U.S. counsel advising the outgoing party on the deal from their U.S. legal, regulatory, and tax perspective. And you'll need Cayman counsel advising the incoming party on their obligations under Cayman Islands law, particularly regarding that crucial BOTA filing we discussed, or any other entity-specific compliance matters.
Okay, so at least 3 sets of lawyers, potentially. What's a rough ballpark figure for these combined legal fees? Are we talking thousands, tens of thousands more?
It really varies widely. It depends heavily on the deal's complexity, the sheer volume of documents involved, the intensity of the negotiations. But based on the sources, you could be looking at a range starting from, say, tens of thousands of euros for a very straightforward transaction involving maybe well-known parties and simple existing structures. But it could potentially climb up to hundreds of thousands of euros for more complex deals, especially if they involve multiple stakeholders with competing interests, maybe elements of debt restructuring alongside the equity novation, or significant back and forth on those key negotiation points like indemnities.
Okay, tens to potentially hundreds of thousands of euros. That's definitely a serious line item in the transaction budget. What other costs are typically involved besides the lawyers?
Well, you have the mandatory Luxembourg notary fees. These are statutory fees, meaning they're regulated by Luxembourg law. They're required for holding that notarial EGM and drawing up the official deed. The amount is typically calculated on a sliding scale based on factors like the company's share capital and the complexity of the resolutions being passed in the deed.
Okay, mandatory notary fees. What else?
Then you'll have Cayman Islands fees. These usually include the standard annual government registration fees for maintaining the Cayman entity, plus fees charged by its local corporate service provider, the CSP. The CSP charges for maintaining the entity's registered office and making necessary filings, like those BOTA notifications. In a solvent transaction like our case study, these ongoing Cayman fees are generally relatively modest compared to the legal and notarial costs for the deal itself.
Right. Any other fees?
Finally, you'll have some minor filing fees paid to the Luxembourg RCS, the company's register, for filing the notarial deed and its subsequent publication in the RISA. These are usually nominal amounts.
Okay, legal fees, notary fees, Cayman fees, filing fees. How are these costs typically allocated between the parties involved? Who pays for what?
The allocation of all these costs is fundamentally a commercial point, and it's subject to negotiation between the parties. Often, you might see the costs being borne primarily by the incoming party as they are acquiring the position. Or perhaps they're split in some agreed proportion between the incoming and outgoing parties. Sometimes, the Luxco itself might agree to cover its own counsel's fees or contribute to certain common costs, like the notary fees, especially if the transaction is seen as beneficial for the company as a whole, perhaps by resolving a shareholder dispute or simplifying the structure. It's entirely deal-specific and needs to be clearly agreed upfront.
Okay, that gives us a really clear picture of the process, the likely timeline, and the potential costs. Now, let's pivot slightly and touch on the crucial area of tax considerations. As you rightly emphasized earlier, this is just for the non-tax expert, offering a high-level overview. It's absolutely critical that anyone involved in such a deal seeks dedicated professional tax advice from specialists. Okay, let's unpack this. From the sources, what are the key areas to be aware of from a tax perspective, particularly focusing on the potential impact on the Luxembourg company, the Luxco itself?
Absolutely. Tax is complex and requires specialist advice tailored to the specific facts. We're focusing here primarily on potential implications for the Luxco, as described in the sources. Now, our main case study centers on the novation of an equity position changing shareholders via the shareholder agreement. However, it's very common for these kinds of investment structures to also involve associated debt financing, often between the shareholders and the Luxco.
Right, intercompany loans are common.
Exactly. The sources note that a simple novation of debt where, say, the identity of a creditor changes because one shareholder replaces another as the lender, or maybe a debt is transferred from one group company to another, that kind of debt novation is generally considered tax neutral for the original Luxembourg debtor company, the Luxco, provided, and this is always the caveat, the transaction is conducted at arm's length, meaning on market terms, as if between unrelated parties.
Okay, so simple debt novation is usually neutral for the Luxco if it's an arm's length deal. But what about debt waivers? This sounds like it could have a much more significant tax impact for the Luxco, especially if, say, a shareholder who is also a creditor decides to forgive a loan as part of the overall deal restructuring.
Yes, this is a absolutely critical area to get right from a tax perspective, because a debt waiver can indeed create taxable income for the Luxco if it's not structured and documented correctly. If, in connection with the transaction, a creditor, particularly if it's a related party or a shareholder, waives or forgives a debt owed by the Luxco, this relief from indebtedness could potentially be seen by Luxembourg tax authorities as taxable income for the Luxco.
Potentially taxable income. Is there any way around that?
Well, there's a crucial distinction that needs to be made based on the underlying motivation for the waiver.
What's that distinction? How does motivation affect the tax treatment?
Okay, if the debt waiver is clearly a commercially motivated waiver, let's imagine a scenario where a third-party bank forgives part of a loan as part of a genuine restructuring effort for a distressed company, specifically aimed at helping that company recover financially. Then Luxembourg tax law may allow that waiver to be exempt from corporate income tax for the Luxco, but under specific conditions related to financial recovery.
Okay, so commercial waivers for recovery might be exempt. What if the creditor doing the forgiving is actually a shareholder?
That's the more common scenario in these structures. If it's a shareholder-motivated waiver where a shareholder who is also a creditor forgives a debt owed to them by the Luxco, this is often not treated as generating taxable income for the Luxco. Instead, the Luxembourg tax authorities, the Administration des Contributions Directes, or ACD, are likely to recharacterize that debt waiver.
Recharacterize it as what?
They will typically view it not as taxable income, but as a hidden capital contribution from the shareholder to the company. Essentially, the shareholder is seen as propping up the company's equity by forgiving the debt. And this type of deemed capital contribution is generally tax neutral for the Luxco. It doesn't create taxable profit that gets taxed.
Ah, okay. So forgiving shareholder debt can either be seen as potentially taxable income, like any debt forgiveness, or as a tax-neutral capital contribution, depending entirely on who is forgiving it and why.
Precisely. And the sources strongly emphasize that for these shareholder-motivated waivers to be successfully treated as tax-neutral hidden capital contributions, you absolutely need meticulous legal and accounting documentation. You need to clearly support this characterization and the underlying commercial rationale. You have to be able to clearly demonstrate to the ACD that the waiver was made by the shareholder acting in their capacity as a shareholder, maybe to support the company's equity value or improve its financial structure, rather than just acting as a simple third-party creditor for giving a debt.
Got it. Documentation is absolutely key for the tax authorities to accept that shareholder contribution characterization. Okay, what about transfer pricing? That always seems to come up in international structures.
Transfer pricing is paramount, absolutely critical in any cross-border transactions involving associated enterprises, which is exactly what you often have when the incoming party is related to the Luxco within a wider consolidated group structure, or if there's ongoing financing between related parties post-transaction. The fundamental principle, globally recognized and strictly applied in Luxembourg, is the arm's length principle.
The arm's length principle. Remind us what that means in practice.
It means that any transactions between related companies, this could include the terms of any intercompany loans or financing that might be put in place after the novation, or how group services are priced between entities, or even the price paid for the shares themselves. If between related parties, all these transactions must be conducted and priced exactly as if they were taking place between completely unrelated independent parties negotiating freely in the open market.
And what happens if the Luxembourg tax authorities think the pricing isn't arm's length? If it deviates from that standard?
Any deviation that they believe results in profits being artificially shifted out of Luxembourg, or perhaps not being shifted into Luxembourg when they should have been based on arm's length pricing, can lead to the ACD making upward adjustments to the Luxco's taxable profits. This directly results in additional corporate income tax liabilities for the Luxco and potentially penalties as well. Transfer pricing compliance is a significant area of focus for tax authorities in Luxembourg and, frankly, everywhere else.
Okay, arm's length pricing is non-negotiable for related party transactions. Finally, on tax, what about capital gains? What happens from a tax perspective when the outgoing party, our U.S. investor in the example, actually sells their shares in the Luxco as part of this whole novation and exit process? Does the Luxco itself have any tax issues related to that gain?
Generally, no. The tax treatment of any capital gain realized by the outgoing party on the disposal of their shares in the Luxco is typically not a Luxembourg tax issue for the Luxco itself. Instead, that tax treatment will be determined almost entirely by the tax laws of the outgoing party's own home jurisdiction. So, the United States, in our case study example, and very importantly, by the specific provisions of the applicable double taxation treaty that exists between the U.S. and Luxembourg.
So the treaty dictates who gets to tax the gain.
Largely, yes. Luxembourg law does reserve the right to tax capital gains on shares in certain specific circumstances. For example, if it involves a significant participation in a company that mainly holds Luxembourg real estate. But for most standard share disposals by non-resident investors like our U.S. party, the primary taxing right and therefore the tax burden and reporting obligation for any capital gain falls on the selling shareholder in their country of residence. They need to figure out their liability based on their local laws and the rules set out in the tax treaty.
Okay, so to quickly summarize the key tax points for the Luxco. Be very careful with debt waivers, especially from shareholders. Document them meticulously as hidden capital contributions if appropriate. Ensure all related party transactions strictly adhere to the arm's length principle to avoid transfer pricing adjustments. And understand that the seller's capital gain on the shares is primarily an issue for the seller in their home country, governed by local law and the relevant tax treaty. And again, emphasizing that critical need for dedicated tax specialists throughout this entire process.
Absolutely. These tax points are deeply intertwined with the legal structuring but require specialist analysis and planning right from the outset to avoid costly mistakes.
Definitely. We've covered a vast amount of ground today, really dissecting the entire anatomy of this complex cross-border transaction type. Before we wrap up completely, the sources also mentioned a few key developments in the broader legal and regulatory landscape, both in Luxembourg and the EU, that professionals working in this area should probably keep an eye on. What were those again?
Yes, the environment is certainly not static. It's constantly evolving. One relevant piece of context mentioned was the recent transposition of the EU Mobility Directive into Luxembourg law. Now, while this directive primarily affects specific types of cross-border operations like mergers, divisions, and conversions within the EU, mainly by enhancing employee information and consultation rights in those scenarios, its implementation signals a broader EU and Luxembourg focus. A focus on considering the interests of various stakeholders, not just shareholders, when dealing with complex corporate restructurings.
Okay, broader stakeholder focus. And you also mentioned the new Luxembourg reorganization law that came into effect in late 2023.
Yes, this is arguably one of the most significant recent legislative developments in Luxembourg for corporate finance professionals. Effective from November 2023, it fundamentally reforms Luxembourg's entire legal framework for dealing with financially distressed companies. It introduces modern judicial and consensual restructuring procedures, offering companies facing difficulties new, much more flexible options compared to the previous, more limited legal tools available. It clearly reflects that global shift we talked about earlier towards a rescue culture, one that aims to preserve viable businesses and jobs rather than just pushing them into liquidation. Anyone involved in cross-border finance involving Luxembourg entities really needs to be aware of these powerful new restructuring tools.
Definitely sounds like a major overhaul. And finally, you mentioned the increasing focus of the Luxembourg financial regulator, the CSSF, on technology. What's happening there?
Right. The Commission de Surveillance du Secteur Financier, the CSSF, is indeed putting a lot of emphasis on technology and data. For instance, they are actively preparing the Luxembourg market participants for the upcoming move to a T+1 security settlement cycle, shortening the time between trade and settlement, which is a significant operational shift driven by technology and market efficiency demands.
T+1. Okay.
Oh.
Anything else on the tech front?
Yes, perhaps even more significantly for the future, the CSSF is openly exploring and actually starting to implement the use of artificial intelligence, AI, for its own supervisory activities. This indicates a clear strategic move towards a much more data-driven, tech-enabled regulatory environment in Luxembourg's large financial sector. This will inevitably impact how transactions are monitored in the future and how compliance needs to be approached by regulated firms.
Fascinating times. Okay, what a deep dive. We have truly untangled the complexities of cross-border corporate novations of shareholder agreements today, using that multi-jurisdictional case study as our framework. We started by really getting to grips with the core legal instrument, contrasting Novation's full substitution and, critically, its full release, with assignment's much more limited scope. That made it crystal clear why Novation is absolutely essential for achieving a clean exit.
We then dissected the Novation agreement itself, going through it almost clause by clause. We highlighted those key negotiation flashpoints, like how to handle pre-novation liabilities, and we uncovered some critical, very specific legal requirements buried in the details, like the absolute need for that preservation of security clause under Luxembourg law, stemming from Articles 1278 and 1281 of the Civil Code, to avoid inadvertently releasing collateral.
And we meticulously mapped out the necessary Luxembourg corporate action that extraordinary general meeting held before a notary. We understood both the formal statutory path, with all its notice requirements and thresholds, but also that incredibly useful and efficient waiver path that's so commonly used in private deals, allowing you to properly anchor the shareholder change in the company's public articles of association much more quickly.
We then navigated the offshore checkpoint, didn't we? Uncovering that crucial and often misunderstood nuance in the Cayman Islands context. The difference between a standard holding company's simple BOTA filing requirement versus a CIMA-regulated entity's potential need for formal CIMA approval. That really underscored the vital importance of doing your homework-specific entity-level due diligence when drafting those critical conditions precedent in the agreement.
Finally, we synthesized all these different legal and corporate elements into a practical blueprint. We outlined a typical transaction timeline, acknowledging it can vary. We broke down the significant costs involved, especially those multi-jurisdictional legal fees, and we provided a high-level overview of the key tax considerations for the Luxco itself, like the potential characterization of debt waivers as hidden capital contributions, and the ever-present need to ensure arm's-length transfer pricing.
I think the core insight that has repeated throughout this deep dive is really clear. The successful execution of a cross-border novation of this type. It isn't just a simple administrative task you can tick off a list. Its success hinges entirely on the intricate interplay between precise contract drafting, carefully navigating specific corporate procedural requirements in the company's home jurisdiction, like Luxembourg's EGM rules, and ensuring accurate multi-jurisdictional legal and regulatory compliance, particularly when structuring the transaction's conditions precedent to reflect reality in places like the Cayman Islands.
And for you, the professional listening, whether you're in legal, finance, corporate governance, compliance, mastering these mechanics, isn't just about knowing the rules in theory. It's absolutely vital for competently executing strategic decisions, for effectively managing complex legal and financial risks that span borders, and ultimately for creating and preserving value in these increasingly interconnected international business structures.
Absolutely. And maybe just a final thought to leave listeners with, building on that look ahead section, thinking about the sheer acceleration of change we just touched on. On the one hand, new, more flexible regulatory tools like the Luxembourg reorganization law aimed at company rescue, and on the other, the increasing integration of technology like AI into supervision by regulators like the CSSF. How might these powerful forces reshape the way even seemingly standard bread-and-butter transactions like these corporate novations are approached, documented, and executed in the very near future? What does that potential reshaping mean for how you need to continue to stay informed and adapt your own practices?
That's a great provocative thought to end on. How will regulation and tech continue to change even the fundamentals? This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.